In a major decision today, the Supreme Court ruled that states cannot use race as a factor when drawing congressional districts. And of course, the Democrats are freaking out over it. We'll get into the legal discussion in a minute or so, but first, I want to show you the reaction from the Democrats. Here's Mark Elias, founder of Democracy Docket, claiming that the opinion says that black people can vote for their preferred candidates as long as that candidate is a Republican. Here's Hakeem Jeffries accusing Republicans of voter suppression. And later, he turned around and said that it's actually Republicans who are racial gerrymandering. Keep in mind, the Supreme Court just said today that racial gerrymandering is illegal, and that is the decision that he's upset about. Now, my goal for this video is to let us engage in a semi-serious legal discussion. I want to give you a deeper understanding of this decision beyond the headlines, because this is deeper than just racial discrimination is bad. As we'll get into, the court sometimes allows discrimination based on race. Watch the full video to learn when, why, and how this case was different. I want to equip you with the tools to push back when your liberal buddy tells you that race-based districting should be allowed to remediate past discrimination. And we'll do it by going through Alito's actual opinion, cutting through the legalese so you can actually understand it. But first, I think it's important to show you the background of this case. The case is Louisiana v. Callais, and the fight over the congressional map started back in 2022. Louisiana put forward this map, which looked almost identical to the old map they used, which I'm showing you now. The new map was challenged in court because it had only one majority black district in a state where about 1/3 of the population is black. The lower court struck it down, saying that having just one majority-minority district violates Section 2 of the Voting Rights Act. According to that judge, Section 2 requires Louisiana to create a second black majority district. So, in response, Louisiana had to redraw its maps. This was the new one, drawn specifically to include 2 black districts. You'll notice that it looks really wonky. In order to get 2 majority black districts while protecting the state's political interests, they had to weave together a district that stretches all the way from Shreveport down 200 miles diagonally down across the state to Baton Rouge. This is on top of the district that already snaked from Baton Rouge over to New Orleans. These 2 districts stitch together the most predominantly black regions of the state while deliberately avoiding white majority areas. And then that map was challenged, and a different panel of judges ruled it an unconstitutional racial gerrymander. And today, the Supreme Court affirmed that decision, finding that Louisiana's new map with the 2 majority black districts is unconstitutional. Why? Because it specifically took race into account when drawing those districts. The case centers around Section 2 of the Voting Rights Act, 52 U.S.C. Section 10301. Section A says that no voting qualification or prerequisite to voting shall be imposed on account of race or color, which, fair enough. Section B, however, is where the real fight is. Section B says that a violation of Section A is established if it's shown that the political process is not equally open to members of a particular race, and that those members have less opportunity to participate and elect representatives of their choice. It also goes on to say that the extent to which members of a specific race have been elected to office can be used as one circumstance in deciding whether the districts are fair. But it says that this is not to be construed as minorities having a right to elected members equal to their proportion in the population. Now, on to the opinion. Justice Alito delivered it, and he opens by saying that the Constitution forbids the government from using race for decision-making purposes in nearly every context. Then he frames the lawsuit like this. Does compliance with the Voting Rights Act provide a compelling reason for race-based districting? And his answer is clear. Compliance with Section 2 could not justify Louisiana's use of race-based districting. He goes through a short history of the Voting Rights Act and the cases surrounding it. One specific case he mentions is White v. Register from 1973, where the court found that Texas was using a districting board meant to specifically cancel out or minimize the voting strength of racial groups. Today, many people point to White to support the argument that race must be used when drawing districts. Your liberal buddy might say that because White struck down Texas's attempt to cancel out minority votes, states must secure minority votes by drawing districts specifically for those minorities. But, as Alito points out, that's not what White said. Instead, White said that you can't intentionally cancel out minority votes. You can't say, let's make sure that black people or Native Americans or Asians don't have a say. What it does not say is that minorities have to be the majority in a district. Alito goes on to talk about other racial gerrymandering cases, and he points out that the typical discrimination cases require strict scrutiny, which means the government must have a compelling interest that justifies its use of race as a factor, and that its use of race is narrowly tailored to achieve that interest. If you study constitutional law for just like 5 minutes, you'll learn that strict scrutiny is basically a death knell for any law, with only a few exceptions throughout history. But in racial gerrymandering cases, the court modified that rule. Now, instead of any use of race automatically triggering strict scrutiny, the court said that strict scrutiny only kicks in if race was the predominant factor. Alito says the court has never actually decided whether compliance with the Voting Rights Act counts as a compelling interest under strict scrutiny. But now the court has to decide that question because a lower court specifically told Louisiana that they had to racially gerrymander to comply with the act. Alito then walks through a brief history of the case, which is essentially what I outlined earlier in this video. The first map got thrown out for not giving black voters 2 majority districts. The second map got thrown out for giving them 2 majority districts. So the Supreme Court absolutely had to step in here. Alito reminds us of the general rule that the Constitution almost never permits the federal government or a state to discriminate on the basis of race. The Supreme Court has allowed race-based treatment in only 2 narrow situations. The first is using race to decide where to place inmates in prison with the purpose of preventing race riots. The second is when race is used to remediate specific, identified instances of past discrimination that violated the Constitution or a statute. But it is important to note, the legal argument being made wasn't about whether the new maps properly remediated past discrimination. It was whether compliance with the Voting Rights Act itself is a compelling interest that allows states to use race-based districting. They essentially wanted a third recognized compelling interest to justify racial discrimination. To strike down that argument, Alito starts by offering a concrete, functional interpretation of Section B of the Voting Rights Act. The baseline you compare minority voters against is the chance enjoyed by the non-minority voters to secure the election of their preferred candidates. And that chance is determined by the voting preferences of the voters in each district, which in turn depends on the districting criteria used by the state when drawing districts. He goes through a list of acceptable criteria to use, including the necessary ones like the number of districts and equalizing population between districts, and then a list of permissible ones like minimizing changes from the prior map, contiguity, not splitting counties or cities, protecting incumbents, and yes, even promoting the prospects of a particular political party. These criteria result in districts where any randomly selected voter's opportunity to affect election outcomes varies depending on their voting preferences. But, Alito says, that is all that is required under Section 2 of the Voting Rights Act, that a state draw districts based on permissible criteria, giving voters whatever opportunity to affect election results flows naturally from those permissible criteria. In other words, Section 2 does not require the state to adjust districts to increase minority voters' chances beyond what those neutral, lawful criteria naturally produce. Alito then clarifies what the focus should be in these cases moving forward, whether there was intentional racial discrimination. If there is a strong inference of intentional discrimination, then a district can be struck down as an illegal racial gerrymander. The example Alito gives is a state's neutral, allowable criteria producing numerous maps that all accomplish every goal of the state legislator, and some of those maps minority-majority districts, all of which get rejected for no legitimate reason in favor of a map with 0 minority-majority districts. In that case, there could be an inference that race was the deciding factor and the district could be shot down. Alito then makes clear that the court will not be fooled by people pretending that pure political gerrymandering is the same thing as racial gerrymandering. Given the voting patterns of minorities, it's easy to argue that a congressional map that favors Republicans was actually racially motivated. But Alito forewarns that that will not be enough to win the case. Democrats ought to prove that race was the driving factor, not just political advantage. And that will be tough to prove absent some outrageous statement from someone on the redistricting board. He also states that it's impermissible for plaintiffs to present maps that are drawn specifically with race in mind. In order to win a Section 2 voting rights case moving forward, plaintiffs must present alternative maps that achieve all of the state's neutral objectives, while still showing that it's possible to create minority-majority districts within those same neutral constraints. And finally, Alito ends by summing up the final ruling. Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating their legislative districts. Okay, now that that's done, I want to focus for a quick minute on what this all means. Do you remember what I said was the second compelling reason for the government to use race in decision-making? It's to remedy past discrimination. That was most famously the rationale used in college admission cases, what we call affirmative action. And if you recall, probably about 2 years ago now, the Supreme Court struck down affirmative action. They struck it down partly because they decided it was no longer necessary. If you go back to the 2003 case, Grutter v. Bollinger, the court said its approval of affirmative action would not be permanent, that affirmative action was meant to be sunset once the goals were achieved. And right now, it's hard to argue that those goals have not been achieved, considering the fact that about 13% of college students are black, which is roughly proportionate to the general population. Alito didn't mention this in the opinion, but if Louisiana, the Democrats, or your liberal buddy had tried to justify the maps under the remediation of past discrimination exception, the court could have struck down racial gerrymandering on the same grounds as they struck down affirmative action. If racially drawn districts were once necessary to achieve black representation in Congress, they're no longer necessary. Right now, roughly 60 members of the House are black, which is about 14% of the House. And more tellingly, half of them come from white majority or white plurality districts. We do not need black majority districts in order to get black members in Congress. The current makeup of Congress proves that. Instead of crying about this is a decision that should be celebrated by both Republicans and Democrats because it signals that this country is on the right path. No longer do we need to use race to give representation to people of color. No longer do we need to legislate the racism out of the general public. Right now, the United States has the most willfully diverse government in the world. About 28% of the House is minority, about 16% of the Senate is minority. We have no mandated racial quotas in Congress like they do in Singapore. We have no proportional representation laws like they do in New Zealand. Instead, we the people have elected minorities into positions of power. That is something to celebrate. Our country is the least racist country on earth. The Democrats can't tell you that because it would make nearly all of their talking points null and void. So instead of listening to their doom and gloom, be happy. Celebrate the Supreme Court's opinion. Celebrate the progress we've made with racial tensions in this country. And simply put, celebrate America because America is still the greatest country on earth. Subscribe and like the video for more from me. I'm trying to build a brand based on honest, reasonable takes and not the performative outrage you get from so many online these days. If that resonates with you, subscribe and head to my Substack to get new releases emailed directly to you. With that, I'll see you next time. Thank you.